Appeals, District 138. I bring before you today House Bill 1599, the Missouri Adoptee Rights Act. This bill gives Missouri-born adoptees the opportunity to obtain a copy of the original birth certificate, the same as any other Missouri citizen, and to do so without a court order or any unnecessary expenses. As you know, when a person is adopted in this state, the original birth certificate is sealed, and the adoption records are closed, and an amended birth certificate is issued. And so that's what the language means when it says the original birth certificate. Some people don't realize that that's the case. But that becomes that person's identity, with some unusual circumstances that could change, but most of the time that becomes their identity. This became a concern of mine because of a constituent, Diane, and Diane is here today. Diane is a great-grandmother. She can't get a copy of her original birth certificate. I'm telling you folks, that's a crying shame. We've got people in their 80s. They don't want anything. They don't want to go stalk somebody. There's nobody to stalk. They just want a copy of something that's rightfully theirs. Diane's one of those people. I've heard it said that birth mothers will be able to sue us because we're breaching a contract, we're breaking a promise. I'm going to tell you, there'll be lawsuits coming, all right. I don't think it'll be the birth mothers, whoever they are, they're supposedly secretly hiding out there. I think it'll be the people that have become subordinate in nature, second-class citizens called adoptees. I think one day, if we don't get this corrected while we have a chance legislatively, we will see an uprising and the state will get sued, rightfully so, because I believe it is a violation of not only the U.S. Constitution, the 14th Amendment, but also Article 1, Section 2 of the Missouri Constitution. Both of them clearly say that every citizen will be treated equally with equal rights. It doesn't say, P.S., by the way, adoptees, sorry about your bad luck, but you're not included in the wording of this Constitution. It says all people will be treated equal. There's about 500,000 people out here that would be immediately benefited by this, so I'm not sure where this fractional group is at that this is wanting an anonymity, because we can't promise that. Not in this day and age. It isn't possible. You can't do it. If somebody did, who was that promised it? Sure wasn't the Constitution of our country that did it. So there's a fraction of people out there, apparently, somewhat mythical fraction, I believe, that we're trying to protect. In the meantime, we're leaving 500,000 people out there just to fend for themselves. When we got elected, we all took an oath of office. Every one of us put up our right hand. And the first words of that oath of office say, I do solemnly swear or affirm to support the Constitution of the United States and the state of Missouri. It doesn't get any more plain than that. I want to bring something to your attention that I find interesting, and I hope you do. Can you imagine? Ancestry.com is one of the most popular sites on the internet. It's fascinating. Unless you're an adoptee, you don't know who you are. I mean, it would be good to go and study the family that raised you and became mom and dad to you in every way. I don't think you'll find an adoptee that isn't appreciative of that. But there's a hunger inside people who are adopted to know. Just simply know. Just like you all want to know. You want to know where you came from. It's amazing what you can find out on a website like that if you have the right information to do it. We're not hiding the fact that, yes, by going in and being able to just get your birth certificate like everybody else, there'll be some information there that will assist you in locating your birth parents. That doesn't mean it'll happen. You'll just have access to it like everybody else does. Doesn't mean you become a stalker. The person's still provided with privacy. They can say, no, I don't want anything to do with that. I want to just share very quickly, and then I want the expert folks to get up here and have you an opportunity to hear from them and to question them. I'm not the expert, just the bill handler. I have had hundreds and hundreds of emails, dozens of phone calls, dozens of letters from all over of people urging me to keep the fight, get this bill through. Not one. I can't say that about any bill I've ever had except the consent bill. Not one person said, are you nuts? What's the matter with you? Everybody says, charge on. The only resistance I've ever found is right here. That's it. Right here. Thank you. Thank you, Mr. Phillips, for creating this long overdue bill that may override the antiquated current Missouri adoption laws. No person should have the right to take this basic civil right away from me. We live in an age today where a person now has the right to marry someone of the same sex, has the right to be able to add them to their medical insurance as a spouse, and the right to adopt a child. Yet Missouri says I don't have the right to know my own heritage, my family medical history, my siblings, my real birth. One more. When does a birth mother's right to privacy end and my rights to know begin? At my age, I'm not looking to cause trouble for my birth mother. I get angry that I cannot have the information that other people take for granted. Yes, I paid the state $50 to get my non-identifying information. I received 3 pages of information with all the identifying information whited out. It amazes me that some secretary in office can see information about me that I cannot. In the interest of time, I'm going to do something a little bit unusual. That will conclude my testimony. I'm going to give you the words of a song that describes, I think, pretty aptly adoption. It's called A Special Kind of Love. She did not want to sign the adoption papers, knowing she'd never hold him again in her arms. Teenage girl faced with desperation. It broke her heart to know she couldn't raise him alone. A couple comes to a children's home to get him. Eyes filled with eagerness, hearts filled with joy. This was the baby to make their dreams come true. They had prayed to God that He would send them a boy. And it takes a special kind of love. The love that's not dependent on mere flesh and blood. You have to have a special kind of love. I thank God He sends someone who does. They never treated him like anyone but their own. They gave him much more than just a family name. He had love and caring like few have ever known. Without them, I know, it had never turned out the same. But out there somewhere's a lady who wonders now and then about the child she gave up long ago. God can hear her question on her knees in prayer. Lord, how's he doing? I just need to know. That, Madam Chair, thank you. Happy to take any questions.
Gentlemen, thank you for your testimony. Are there questions for the sponsor of the bill? Yes, Representative Diane.
To comment.
Yes.
To comment. Thank you. Thank you, Representative, for bringing this bill forward again this year. I'm hoping that this year we can take this across the finish line and vote it into law. Last year when we discussed this bill, all I had to do was put myself in their place, the ones wanting to know who their real parents are. And I knew then that there was no doubt in my mind that I was going to support this bill. And I got an email from somebody this week, and I think it kind of summed it up for me. It was very short and sweet, and it just said the era of sealed birth certificates is over. So I urge everybody on the committee to support this bill. I just think it's so important. Thank you.
Thank you. I spoke to a lady that worked in the pregnancy lifeline down there for years and years, and I ran this bill by her, and I said, is that something that's going to affect your line of work? And she said, absolutely not. She said, the women come in, they've got three choices: abort, have the baby and keep the baby, or give the baby up for adoption. She said, I'm telling you, that once they see that ultrasound, you can scratch off abortion. They're done with that every single time. And she said, most of the time, the struggle then becomes reasoning with them that you can't raise this child on your own. You just can't. They want to pretty desperately, she said. But the beauty of it is modern day adoptions are reasonably open. They're not locked in the past like this. This has been around since the early 1900s. So many of these people we're trying to protect aren't with us anymore. You know, and the folks that we're trying to help are mature adults. So, thank you for your inquiry.
Representative Beverly,
To inquire?
you may.
I do too. Thank you for bringing it forward again this year. And, yeah, we can talk about a lot of benefits also from this. Do you have any examples like the medical records or anything like that helps? That could help in that line?
Yeah, that's a great question, because the medical records are so important in this day and age. And really, frankly, the adoption records themselves, they're kept in a totally different place. And so they're not apt to have anything in there that's going to help you medically. It's unlikely. So you really need to get that medical information from the source. And I think you'll hear some testimony today that will convince you that that's the case. And the sooner the better. The sooner you know what risk you have ahead of you medically, you know, based on your lineage, your family background, the better off you are.
Yeah, I know that when I go to the doctor, or fill out a bill, it's got your family history.
Right.
And they leave a lot of time on that information. So that was one thing. I hope you do have some testimony.
Yes, we will have. Yeah. Thanks.
Representative Beard.
Thanks to inquire. Thank you also, I appreciate what you've done. Just to make sure I'm clear, this bill really just authorizes someone to get a birth certificate.
That's right.
Correct, and that's it. But one question I had, that there's a restriction here that would only allow that benefit to anyone who's over the age of 18.
Right.
Can you tell me what the rationale was behind, picking that age?
Well, I think it's the age that we've accepted as being adults. Can't buy liquor and consume alcohol at that age, but almost everything else you can. I think when you start getting too much higher, we had this discussion last year about raising it to 21. And I think when you start getting higher and higher and higher, to go back to Representative Remley's point, the earlier you can have access to that, the better. And honestly, I don't think that's even a very concerning point in this, because of all the open adoptions that there are today. We're pretty much dealing with somebody from, that's got some age to them.
Well, that's kind of my thought. Yeah. If I was 17-year-old,
You're not done.
and I wanted to get a copy or not, do you know what if my adopted parents agreed, me over to get one, why not?
Yeah, and most people are very appreciative of their adoptive parents. That's mom and dad.
Right. I guess my question is, why not allow someone who's younger than 18 to acquire that?
Yeah, I just don't think the maturity is quite there yet. That's just my opinion. I think there has to be an age set of some sort, and 18 seems to be the most logical. I just don't think a 13, 14, 15-year-old child probably is ready to do that. Just me.
Okay, so that was the reason to put the age in there.
Sure.
That's pretty much the standard, I think, across, the country and states that have established this.
All right, let me just see who's here today in the room. How many are here to testify on this bill? On this bill. There's another bill here after this bill, we'll have ample time for. So let's proceed with those. Do you have some witnesses to call?
Yes, I'd like to have Heather Dodd come up first. And at this point, we've got some handouts for the committee. They got them? Okay. Yeah.
Good afternoon, Madam Chair, members of the committee. I want to thank you for having us here again. Had to chuckle a little bit. Seems kind of ironic for any Bill Murray fans. We're here again on Groundhog Day. Anyway, House Bill 1599 is a solution to a big problem. It's not a small issue. It's been estimated that there's over 500,000 adoptees from the state of Missouri alone. Missouri was kind of a central hub in the U.S. where we had homes in Kansas City and St. Louis for unwed mothers, and they just happened to be on the train line where it was convenient to send an unwed mother to those locations. So our numbers are actually a bit higher than in some other states. Adopted adults are the only adults in the U.S. who are often denied access to their own information and required to get parental permission for their own information, thus making them feel as though they are second-class citizens. And the current laws that claim to allow them to have that information, they're failing consistently. And an adopted person should be able to get their information through the adoption records laws, and it looks great on paper, but when you actually go through the process, many of them are not getting anything at all. So the information that you have in front of you, I tried to kind of summarize and outline how the process works, how we got to this point that we're at today, and why House Bill 1599 is the solution to the problem. Understanding how we got here, adoption, of course, happens for many reasons. It doesn't matter if the person is 10 or 17. If they know that if they're an older child that knows their information, regardless of the situation, the birth certificate is sealed and can only be reopened on a court order. Shortly after a child is born, even if they know that the child will be adopted out later, they still generate an original birth certificate with the birth parents' names on it. It is a vital record. Then from after the birth, the child goes, after relinquishment, the child goes into temporary custody of like an agency or foster care system. And during that time, the original birth certificate stays with the child. If something happens that for some reason that child is never adopted, maybe a medical condition and nobody ever commits to adopting the child, or whatever the case may be, they maintain their original birth certificate all the way through. When they turn 18, if they're not adopted, they still have that original information. After the child is placed with their potential adopted family, they keep the original birth certificate. The possible adopted family will have the child sometimes for months or even years before the adoption is finalized. So they still have that original birth certificate attached to them. So the point of all of that is The birth certificate is not actually amended until the legal adoption takes place, at which time the court recognizes the adopted parents as the legal parents and allows the child to have the name of their adopted parents and closes the record. A birth is a public record in Missouri, so it closes that public record of the original birth information and recognizes the amended information in the eye of the public. And this all came about to help prevent scrutiny, public scrutiny, because there were so many stigmas put on being a single mother or a childless couple or a fatherless child. As a point of adoption also, the local county court makes an adoption, they create an adoption record and file it away in a way that is up to each individual county clerk. So it's going to be different in every county. So sometimes this can cause a problem because they'll put it under the birth parent's name or an alias like Baby Jane Doe. And it just makes it really hard when the adopted person goes to ask for information for that county clerk to even find anything at all. I think I might have got ahead of myself just a little bit here. So the birth certificate is amended after the adoption takes place. The county clerk sends a decree of adoption to the vital statistics to let them know that this is the point that we need to seal the original birth certificate and issue the new one with amended information. If that adoption is annulled for any reason, for example, if one of the parents were to pass away and the other one didn't feel they could continue to parent the child goes back into the system, the original birth certificate is restored to them. There's multiple ways that a child will maintain or receive their birth certificate back. Now, onto adoption records. To understand why the system is broken and what it is we're trying to fix here. When a person turns 18 and they're able to go to that county facilitator and ask for their information, first they have to know what county their adoption was finalized in. And if you were 2 or 3 years old when your adoption was finalized and nobody in your family ever talked about it, you may not know that information. They may request that the court release identifying information if they can find the file, but then they've got to pay $200 to $500 oftentimes for a court searcher to locate the biological parents and determine if they are deceased or alive. And if the parents are deceased and if that can be proven, the information is released. But if the parents are still alive, the court searcher would have to get permission from those parents, even if the person who is searching is 50 years old, they still require parental permission for that information. If the biological parents are not located, the adopted person is not reimbursed the fee, and they receive no identifying information. And a lot of times the person who's conducting the search can be a court clerk or somebody working for the court who is not an experienced genealogist or private investigator. So, that's really makes it difficult. If they say they cannot find the parent, how do we know that they put forth their best effort to make that location? If the parent relocates or remarries, or in this day and age of cell phones where you can't open up the phone book, the right pages just to find somebody, it makes it really, really difficult on the courts as well. It's a huge burden for them. Our biggest problem has been that the courts just don't find the records. They just cannot find them. Again, we surveyed all of the county courts last year. Many of them reported filing those records under the birth mother's name, the child's birth name, an alias, or the current clerk did not know how the previous clerks had filed that information. So And there was one court that I called, and all they would tell anybody was, you just need to hire a lawyer. Another reason that records are not found is, not every adoption went through an agency or social services. A number of them were facilitated through lawyers as well, or smaller agencies that kind of came and went. And some of them did not necessarily pass on the information to another responsible party to maintain those files. And some adoption records have been destroyed in fires in the past. So multiple reasons why if an adopted person goes, they will be told, no, we have no information for you. So what about the state registry? The state registry, mutual consent, where you're supposed to be able to, mother and child come and sign up and they'll make a match. The problem with that is both parties must know enough matching information. If the child's birth certificate says St. Louis on it and they don't recognize it maybe because it's St. Louis County, the mother might put that the child was born in, Baldwin, Missouri, and then the child put St. Louis, and then we don't have a match. And there's several other scenarios, but I won't drag that out. The time of submission. If the son submits his form in 2005, but mother submits in 2015, then the state registry may try to contact the son, and his phone number has since changed or his address has changed. But the real kicker is the county verification. The state registry is supposed to be able to get the adoption file from the county level to be able to verify if these two people are a match or not. And it's my understanding that oftentimes when they request that file from the county, they're getting the same reports that we are, that those records cannot be located. So the registry is just not working, and that's why their percentages of matches are so extremely low. As to medical information, it's pretty straightforward. I was 17 when I had my first son, and I really didn't know anything about my family medical history at the age of 17. I know a lot more about it now than I did then. So had I given up my child, the information in the file would have been minimal. And that's all most adoptees do find, is just a little bit about family history. But it's all outdated. The parents cannot be forced due to HIPAA laws. We cannot legislate that they give over medical information. It has to be voluntary. So, but better solution than for the adopted person to be able to go directly to mom and say, I need this information, are you willing to give it to me? And of course, like anyone else, she has the right to say no. But that is the only reasonable way to get that information. Now, also, county courts will allow biological parents to submit medical information to be put in the file for the adopted person to find later on. But the problem with that is most biological parents don't even know what county their child's adoption was finalized in, because it typically is finalized in the county where the adopted parents live. So if a child was born in St. Louis but adopted in Hannibal, the biological parent has no way of knowing where to send that medical information to. So again, the best solution is for the adopted person to be able to reach out to that parent if you need to. Privacy issues. Missouri law is designed to equally protect the adopted person, the biological parent, and the adopted parent from the public scrutiny that was once an issue surrounding adoption. We're not just talking about birth mother privacy, we're talking about privacy for the entire situation. However, when you look at the state laws, actually adoptees do have access to their original birth certificate. They do have access to try to reach out to their parents. it's obvious in the law that it was never intended to prevent the adopted person from their biological family was. It was intended to keep the public out of their business. Also, on the issue of privacy, the system that we have in place today is actually causing more harm than good. The day and age of social media, and we have countless people holding signs on Facebook. They circulate through thousands of people stating all of their basic information, when they were born, where they were born, and really it's probably not the safest thing for the adopted person to be putting out there, but they're finding themselves desperate because they're not getting answers through the state. So, you know, as a result, parents are being contacted by 10 of their friends who recognize that, hey, that information looks familiar. There's no privacy in that. There's no dignity in that. Also, for $99, you can buy a DNA test from Ancestry.com. And adopted people have this newfound love for Ancestry.com because you can submit your DNA and it will connect you with second cousin Susie, who then asks first cousin Sally, hey, do you know anybody in the family who might have had a baby back in the day? So how's that for keeping things private and dignified? It's best, I think, and I sure hope that you would agree, to allow the adopted person to know that his mother's name was Jane Smith, and he can go directly to her and say, I think I'm your son. May I have information for my medical history, and would you like a relationship? And she has the opportunity and the same rights as everybody else to say yes or no. So in summary, many adopted adults don't know where their adoption was, where it was finalized. Many county clerks have filed adoption records in a way that cannot be located by the current clerk. Some adoption records have been genuinely lost or destroyed. Most biological parents don't know where the adoption was finalized, and they can't submit medical information. And adopted adults are the only class of citizens still required to get permission from their parents to know the names of their biological relatives, even though it's illegal in the state of Missouri to marry your brother or your sister. Requesting information through our system is costly and time-consuming. Since adoption facilitators and county courts don't maintain contact with the biological parents, the parents can be difficult or nearly impossible to find. Social workers and county clerks are often not properly trained genealogists and have a difficult time locating the biological parents. The registry is dependent on this county record system. Medical information can't be provided if nobody can get the parent to locate it or to get it to them directly. And again, if the system fails to help the adopted adult, he or she often turns to public means of finding information rather than privately contacting those family members. The solution to these problems in Missouri is vote yes on House Bill 1599 and let adopted adults have direct and affordable access to a copy of their own original birth certificate. I'd like to thank you for your time, and please, if you have any questions, I'm open to answering.
Thank you very much for your testimony, and thank you for providing information. Are there any questions?
Thank you for your testimony. You know, when we heard this last year, I was in pretty strong opposition to this bill until I, you know, realized just what type of system has been created and how the cards are stacked against people and knowing who they are and the loops that you have to jump through in order to obtain this. And you know, wow, it's amazing you know, what people have to go through to find out who they are. And, you know, I'm in full support of the bill, and I just thank you for your testimony and displaying what mess the current law and system is, and how we need to do something about it. So, thank you.
Thank you.
All right, thank you very much. Be sure and leave a witness form. We spent about 18 minutes on that testimony. Do you have another witness that you'd like to
Yes,
call?
we knew that would be the lengthy one, but we've got a couple more for sure. We have a birth mother here who would like to testify, but right now we have a judge that deals with children's cases and stuff, and I think most judges aren't real long-winded, so I think
We're honored to have you here. Thank you.
we certainly are.
Madam Chair, members of the committee, my name is Dan Kellogg, and I'm a circuit judge in Fifth Judicial Circuit, which is Buchanan and Hampton counties up in northwest Missouri, mainly up in St. Joseph. I've been a judge a little over 20 years now, and I've presided over juvenile cases for about 15 years now. Served 6 years on the Board of Trustees in the National Council of Juvenile and Court Judges, which is the largest judicial organization in the United States of America. So I'm very much in tune to issues involving children like this. And frankly, I met Representative Phillips for the first time today. So this isn't like some guy, he just called up and said, hey, no, I heard about this bill, saw it on there, and I called his office and said, I'd like to come down here and testify on behalf of this. I would just say, I think that this is, and echoing what's been said, and I'll keep it very brief, this is something that's long overdue. I think it's only fair to for these children who have been adopted to get that information and to have access to that information, to their birth certificate. I can go back and trace my genealogy back to 1650. I'm blessed I can do that because I've got the paperwork and all that. I can do that. I have an adopted son, so he can say that too. But you know, there's a point. You know, he may want to see his own, you know, biological blood ancestry. I'm going to change the fact that he's still my son. But you know, he wants to be able to trace back on that too. He should have that same opportunity that I have. And so I just think that's very important. You know, we've heard a lot of the talk about the courts, and I can tell you, I know how the cases are filed in my circuit, but as has been said, they're filed all different ways. And as you all are aware now, we have e-filing, and you can imagine if somebody was trying to file their medical background, so it could be a part of this, you know, that would just be a complete nightmare. So I don't think that that's really something we need to look into. I just think this is just something that's really important. Again, it just gives these folks a chance to get that information. Listen, as a judge, you know, I do a lot of things every day and every week, but the one thing that we get to do that's a happy thing is adopt. And I will tell you that I have, you know, I have had adoptions where the birth mother, you know, she has selected the family, and she has been in there when the pass up is current. I have taken the baby from the birth mother and given it. So I mean, it's a very emotional and just a very happy thing. But you know, those adopted children have a right to know that. And we're not talking about somebody who this has happened and you know they're going to knock on the door or find something out. You know, a year later, we're talking about it's 18 years that these children have to be before they even have a right to going after it. So this isn't, hopefully this isn't going to be something that's opening up old wounds, but it's simply giving them a chance to get that information to which they're entitled. So I just wanted to offer that up to you. I know you've got a lot of people who are more experts on all this than I am, but I wanted to say that I would encourage you. I think this is something that would be great for the citizens of this state, and so I would hope that you would pass it. And I'd be able to have to answer any questions if you've got any.
Thank you. Thank you for being here today. And I'm sure we'll have questions from your learned opinion that you would be able to answer for us. Representative Burnley, did you have questions?
Just to inquire,
You may.
you know, we've heard a lot of testimony, and I've got a lot of emails about this. And I was, as you have been having an adopted child, what is your feeling toward your child if the child would want to see their
That does not concern me in the least. My wife and I have talked about that because, you know, that's still our child. And I think I think he still would consider that we are his, his parents. He's 16 now. And I don't think that's going to change any of that. But I think at some point in his life, he's going to want to know that. I mean, I just think that we all want to know that. We all have that sense of who we are and our belonging and where we are, where we fit in this grand scheme of things that's all put out there for us. So, it does not concern me.
I just got
Sure, I appreciate it.
All right, no further questions.
All right.
Then.
Thank you, folks, very much.
Be sure to leave a witness form for us. Let me just see in the room. Are there those here in opposition to this bill that wish to testify? Representative Phillips, how many more witnesses do you feel you need to call?
Well, we've got birth mother here, a couple of them actually that would like to say something, hopefully briefly. Everybody that came that has something on their mind, they have a unique story to tell, so they'd love to speak to the committee. So it's going to be your call, but there are a couple more that would love to have share with the committee. But
let me see. Who is here for the next bill that we're hearing? How many are here to testify for that bill? Okay. So I think then let's go on this bill 20 more minutes. All right.
okay.
What I'd like to do is be sure that we leave 10 minutes, 5 to 10 minutes at the end. We need to go through opposition and for informational purposes only.
Okay.
So I'll time this and kind of keep us on track. I appreciate the folks that have come in to testify.
Yes, thank you.
Go ahead.
Hello, my name is Marge Wiederholt. I was here last year and testified. Since then, my daughter has found me. She was looking for me. In October of 2014, she became ill with heart problem. Her doctor told her she needed to get medical records. She and her doctor both wrote letters to Catholic Charity asking for medical records. They never got a response. Her brother asked Lutheran Services for help. They called my daughter after a few months, and they told her that whenever she was born, I was in Kansas, the state of Kansas, in prison on a drug-related charge. They also told her that my mother brought her home from the hospital, and 10 days later, they had to take her away from my mother because my mother was selling drugs out of her home. This was a lie. I have never been in trouble with the law at all, and neither has my mother. And if you knew my mother, you would know she would never do drugs. At the same time, I was trying to get a hold of Catholic Charities. They would answer my phone calls. I wanted the papers that I had signed whenever I gave my daughter up for adoption, which I have found out from talking to other birth mothers. They never got theirs either. They said, you can have them for $75, but we have to send you this piece of paper. I said, wonderful. I'll send the $75, along with your piece of paper and everything that I had to do for them. They never sent it. All they sent me was the reunion packets 3 times. They would never send it to me. So I don't feel like they ever wanted me to get the papers that I signed, which they should have given them to me whenever I signed them, but I was only 18 years old. I had no idea. Along with the other birth mothers that I have talked to, we were never promised privacy. I had to do a paper. I had to write my daughter a letter so they could put it in their files. So I don't know how me writing a letter for my daughter whenever she comes to search for me if she ever did, you know? Why would they say that they promised me that I would never be found? They couldn't have promised that. And I actually thought that when she turned 18, that she would be able to search for me. I knew I could not search for her. I knew I had given up my rights. I had no idea that I was giving up my daughter's rights too. This group that I am in, the Missouri Adoption Rights Movement, I guarantee you none of us are for abortion. My boyfriend wanted me to get an abortion. My morals would not go for that. I would have rather, which is what I did, take the humility, be treated like a bad person for getting pregnant out of wedlock and living through that all of my life than to give an abortion. So I would like to thank you guys for listening to me, and I do hope that you pass our bill. Thank you very much.
Thank you very much. Are there questions for this one? Thank you.
Thank you.
Good morning, or good afternoon, committee members. Annette Driver, I'm a registered lobbyist here in the state of Missouri. I've walked these halls for over 5 years or so. Don't have a paid client this year, so I have to stick my head in when I can. I am a birth mother, and I think you remember that I testified before this committee about 3 years ago. And I told you that when I was a college student at Warrensburg, got in trouble, got pregnant. I was not the girl that was supposed to get pregnant. And in shame and secrecy, I went away to a maternity home and I had my daughter. And as we depend on the good decisions of the members of our legislative body to think about what will best serve the citizens of Missouri. I will say that as we're still deliberating over this bill, as I walked the halls of this Capitol, I found my daughter by my works here. And so April 29th at 11:30 p.m., thanks to Heather Dodd and a chance meeting that I had with Representative Don Phillips, I found Aileen Woods. And I will say that, interesting enough, I didn't find my daughter situated. It was not a good match for her with her adoptive family. And at 38, she has been separated from them since the age of 18. And so she basically, all but officially or legally, emancipated herself from her family. And so you're talking about, as I mentioned to you, and as it said, that the birth parents and the birth mothers are being protected. I told you I wanted my baby. And we basically have a love story. It's still in the workings, and we still, like any other family situation, we're basically thawing out. The biological father came to her. She has sisters from him. She has her whole bloodline. My family has an extensive genealogy history set up. The only problem that we're correcting now is that she's not in the family tree, but we're correcting that. But she has an extensive background on both sides of her family that she can actually look and see where she comes from. You can actually look, if I showed you a picture of how she looked when I found her in April and what she looks like now, you could tell. And especially showing her birth records. I have a folder this thick of over 21 years of searching for her. You can see how the unthawing has even changed the way that she looks and the way she feels. My grandson, he's 18 now, and this was our first Christmas, so actually by finding her last April, we've had our first Mother's Day, Father's Day, Thanksgiving. My birthday was on Thanksgiving this year, and our first Christmas. And when she was born on April 7th, so sometimes she actually falls on Easter. I just want to tell you, there's nothing as she's looking at me and her father, and you can see these things clicking for her to see and realize who she is. It's almost cruel and unusual punishment, and it's very unnatural for a mother basically to release her connection with her child in the first place. So you can understand that basically some trauma has happened. And who, if any of us in this room are still experiencing what we went through 17, 18, 19. Lots of things happen and change over time. So we're just saying that while there are mothers out there that you can believe that even if there's a stronghold, maybe they had their child with a stepfather or their sister's husband or something happened. There's no doubt about it. But I almost guarantee you that as a period of time goes by, there is an unthawing, and some mothers do have are still drawn by a stronghold. I was very lucky that I was able to get away from mine. So please consider House Bill 1599 because there are a lot of adoptees out there. Believe it or not, a lot of birth parents as well who want that reconnection and things have changed in time that would allow. Thank you so much for your time.
Thank you. I see you've got your witness form.
Madam Chair, if we could, we'd love to have the committee hear from an 18-year-old's perspective. Okay.
Hi. I'm good. As I said, I'm an 18-year-old. I'm here for HB 1599, and my name is Danica. I'm an 18-year-old adopted child, and I've always had my original birth certificate, and I actually have a copy of it right here. Growing up, I didn't really know my mother and father, my birth family, but because they didn't really want to have contact, they kind of decided, no, I don't really, it's too hard for them. So I respected that, of course, but I always had my information in case I needed to contact them for any reason. And this has had, obviously, a positive impact on my life, an impact that I didn't even know was possible because, like, it's such, I didn't realize what a wonder
hope I'm around to see them graduate high school and start children are all married, you know. But the medical records are vital. They are vital to our meeting. And that's all I have to say.
Thank you very much. Be sure to leave a witness form.
Thank you.
I believe in the interest of time, we can care about that. And probably wraps it up for those in favor. I think we would start covering some of the same ground. I think we've adequately covered this subject.
All right, well, let's see, what, we have those in opposition. So we'll go ahead, who would like to testify in opposition to the bill?
Good afternoon. My name is Laura Long, and for the past 18 years, I have worked as a confidential intermediary with adoptees and birth parents in the courts. I'm one of those bad guys that everybody's been talking about. But I have a degree in social work, and before I was a confidential intermediary, I worked with in the mental health field for 10 years. But I'm also an adoptee. I was born and adopted in Missouri. So I understand where everybody's coming from. However, I am not for this bill as it now stands. I am for the release of the OBC when we have the consent of the birth mother, they are deceased, or when an adoptee is a certain age. I'm also okay if we start from now on knowing that the original birth certificate can be released at maybe age 18 or whatever is decided on. Like most everybody, I came into this thinking, well, of course, every birth mom is going to be overjoyed at my contacting them that their child is looking for them. I've learned very quickly that is not the case. In my statistics show that 60% say yes and 40% say no. And in the last 2 years, it's been actually more 50-50. And to say numbers, it's about 20 birth moms a year say no. And their reasons vary. Everything from, no, I don't really want to open that part of my life up, to a nasty phone call from an attorney who is calling on behalf of their client, and why am I contacting them for any reason. They all have kind of this incredulous, like, how did you get my name? I was told that that was always going to be sealed. And that's even from birth moms who do want to be connected. I have lots of birth moms who do want to be found. And so we make that connection. But so on either side, they both say, I never thought that this would happen because of what I was told at the time of the adoption. So I'm here to speak on behalf of those who say no, is that by reason of their anonymity, they won't be here. I could fill the room with birth moms who don't want to be found. But of course they can't do that because then they're found. So I have talked to lots of birth moms about this. And there, again, I could go into lots of long time detail as to the emotional reasons why they don't want to be contacted. So, and again, I won't go into all that, but I just want to say that there are lots of birth moms. I had an 85-year-old lady, and most of the folks who were not promised anonymity, but who had the understanding that their name would be removed, are usually the older ones. The birth moms who are 50 to 90. So it isn't the younger ones. But most of them, of the older set, 185-year-old lady, she's like, I'm a church-going lady. She had never married. She'd never had any other children. She was just beside herself that I had contacted her and had that this information might get out, and that people in the community, she lived her life being the nice little church-going spinster lady, and if this got out, it would devastate her. And actually, she died 3 months later. So, all the way to, I had a birth mom who we did a search. She said no. The adoptee found her anyway. again, like they're all saying, all the social media and the DNA testing and all that. So found her anyway, contacted the birth mom's other daughter through Facebook and Twitter, never really admitting or introducing herself, but stalking her and bragging about stalking her and contacting, and the birth mom's like, I don't want this. And it was a very, I won't go into the graphics, but she had been a college student. It had not been her choice to get pregnant, and she didn't want, and then nobody in her family had known that this had happened. But when this happened, then she had to tell her daughter. And it's just been devastating to the family to have this person kind of intrude on their, intrude on there and contact everybody around them and let them, made a big, lots of drama. She called me in tears many times trying to figure out what to do. And the best thing she could do was get a restraining order because she didn't even know the girl's name because the girl had never really even contacted them directly to introduce herself. So, and again, I could go into lots of stories, but I just feel like I have to lobby for the birth moms who don't want to be contacted. And as they have talked about, this bill also doesn't take into consideration the current adoption records that are held by the court, because if somebody's going to use that original birth certificate for searching, they'll need that adoption record. And the adoption record law will still be the same. It will still have to have the same limitations to getting it that they currently do. And we are successful many times. I mean, this is what I do. I don't make a lot of money on it. If I won the lottery, I would have done it for free. I mean, I've always said that. If I ever win the lottery, I'll do it for free. Or if we have a state funding for somebody to do it, then the adoptee doesn't have to pay. It's not the issue of pay. It's I have to pay for my expenses in order to do this. And like I said, I've done it for 18 years, and I thank you for your time.
Are there questions for this witness? Representative Neely.
Inquiry, please. So it sounds as if the mental gymnastics that that both, say the biological mom and dad would go through, you think outweighs the mental gymnastics that the adopted child goes through. Is that correct?
Well, if you have a traumatic event in your life, a birth parent comes to it from this perspective. Again, this is my understanding of doing it for this many years. As a birth parent, a lot of guilt and shame was placed on these birth parents back in the day. And a lot of birth parents get over that. They work through it. They say, I don't care what anybody says. I'll have contact with the adoptee anyway. But you have a lot of birth moms who never were allowed, or themselves or the people around them never allowed them to mentally process this traumatic event that happened to them a long time ago. And so if somebody has a trauma, are we going to make them deal with it? I mean, I don't know. That would be the trade-off, is that they still feel that guilt and shame. Well, whether we agree with them or not, we may not agree that they stay anonymous, but we have to respect their position, and that this is a traumatic event. How do you make somebody deal with it?
So you're saying that the mental gymnastics that the biological mom or dad goes through is greater than that of the child?
Could be.
Okay, I just wanted to get that clarified.
I'm an adoptee, and whether I knew my birth mom or not, it doesn't change the person I am. It doesn't, I mean, I still have my family, I still have, I know who I am. I guess I know who I am enough that isn't an issue.
All right, other questions, Representative Mayor?
What do you work for? Is it a firm or is it?
I work for me. I started out, look at my story, I didn't want to take a lot of time, but my story was that 20 years ago, I asked for a search. And after about a year, and there was nothing, I had paid the money, there was nothing, I said, I'm going to see if I can figure it out on my own. And I did. And I was lucky enough that my birth mom did want to have contact. And so, and this was through Catholic Charities in Kansas City. And so I contacted Catholic Charities and I said, your system doesn't work. You need to hire me to do it. And so that's what they did. I have a degree, my social work degree. I have an interest in genealogy. I have a knowledge in research. And I feel like I'm pretty good at what I do. And I have again, with the social work background, I have the counseling ability to talk with the both moms, to kind of help them work through, short of twisting anybody's arm. The goal in every search is to make a connection.
So the people who were born before 1985, the mother could request that those records remain sealed. Is that correct?
Well, it is. I mean, it just is. We contact them to see if they're willing to release their name.
So they were all sealed?
Yes.
Okay, and then now they can have them unsealed if they so choose.
Correct.
And anyone who was born after 1985, who decides if they're sealed or not?
Well, at this point, it's age 18. We can do a search for anybody 18 or over.
Great, thank you.
Other questions? Representative Bratton,
That's it, Claire.
you may.
I guess, in hearing the testimony, the one thing that I guess we speak of the contractual agreement between, the agency and the birth parent, but yet there's 3 people involved within this contractual agreement, but one was left out. I mean, do you agree with that?
I do, but again, at what point does that birth parent who signed over, they signed the consent. They signed over having their name be part of the file. And they signed that
But
release.
does that, because they signed, now that individual has to live their life in constant wonder
We can
and
contact the
inability
birth
to find out?
And it's only until the birth parents are deceased. Even if we
That's a
do a
long
search.
time.
Again, there's no clear answer. I talked to enough birth moms who disagree, that they're terrified that somebody will find out. And I just have to be their voice because they
Well,
can't be.
I heard your testimony that you have people that stalk and take it to this level that's criminal. But is it because we have a process in place that people become so angry with the system that's working against them versus having that ability? You see, do we have a system that's driving people to this action? I guess that's, after hearing the testimony, that's where I could see where people that don't know and want to know, grew up in an abused, household. Now I have this hope or just wonder, but yet we have a system stacked against. And they were never included in the contractual agreement.
Well, we make lots of choices for our children that they may not agree with. And again, when we get older, then we can see what we can find out. But again, if you have an agreement with somebody, before you change that agreement, everybody has to give their approval for the change in the agreement. I mean, if you have an agreement to sell a piece of property, you have to, and you want to change that agreement, you have to have both
If you're
sides.
selling that property without the consent of the other.
But again, you can't change the agreement without everybody's permission.
Thank you very much for your testimony. Please leave us a witness form. Are there others to speak in opposition to the bill?
Good afternoon, Madam Chair, members of the committee, Tyler McClay, General Counsel of the Missouri Catholic Conference. We work a lot with the Catholic Charities Group, and I want to say to the mom that testified earlier that if she'd be willing to give me her information, I would like to help her get her $75.
Already found.
Because I think that's just, to get your $75 back.
I
For Catholic
never
Charities,
sent it because they
that's-
never sent me the paperwork.
Right, no, I want to get you your money back is what I'm saying, so.
No, I never sent the money because they never sent me the paperwork.
Oh, I see, okay.
To even start the process.
Okay, I misunderstood. Catholic Charities is part of the Adoption and Foster Care Coalition. I think their primary concern with the bill, as Laura testified, is that it's retrospective in application. And I think if you look at the 8 states surrounding Missouri, 6 out of the 8 states require, for original birth certificates to be released, require either mutual consent or a court order. And if you look at, and I've got the citations to the statutes in this case surrounding Missouri for you to take with you today. if you look at Illinois, they recently made their birth certificates available to adopted adults in 2011. And before they did that, they had a big public relations campaign, and I think they did it through the Department of Motor Vehicles. And what they did was that they made those original birth certificates available unless the adopted or the birth parents came in and filed an objection to the release with the registry that they have, the Illinois Adoption Registry. So that's just another, I'm pointing that out because it's another way of maybe doing this. I mean, I think our opposition is that it's retroactive because those women that were promised confidentiality and who made their adoptions at a time when the law said it would be confidential ought to be respected at that, for that purpose. And so obviously they can give their consent now and that information can be released. So that's their, the objection that we have to the bill. So I'd be willing to work with Phillips. If he's willing to do that, I'd be willing to work with him to amend the bill in that way.
Thank you. Are there any questions for this group? Thank you very much. Is there anyone here to testify for informational purposes only? All right, seeing none. Oh, well, please come forward. Gotta be quick around here, don't you?
Hi, I actually work for an adoption agency, and so obviously this affects my clients. My name is Elizabeth Allen. I'm the Director of Placement Services for Gift of Hope Adoptions in Columbia. And I actually more came to see if you had questions from the adoption agency perspective. But I can see both sides. I work with both sides of the clients. I can tell you honestly, in the 10 years, roughly 100 adoptions I've done, I can think of maybe 2 birth moms that I've worked with who said, please tell them not to contact me under any circumstances. For the most part, most of my clients want open adoptions. When I ask them the question, would you be okay with your birth child later getting their original birth certificate? The answer is usually, what do you mean they can't get their original birth certificate? They understand just through the counseling and the process that we have, the adopted family will get a new birth certificate. But we actually go through a lot of counseling when it comes to filling out the birth certificate, because sometimes they don't know that they can give the child a different name, that can be changed later, or they don't know that it's sealed. So we do try to educate, and all of the adoptions that go through our process as an agency, we do ask for medical history. Of course, there are limitations. You may not know all of your medical history, but we do try to pass that on in a HIPAA compliant format as best we can. And I can also testify to the fact that the executive director, who's been doing adoptions here in Missouri for 35 plus years, he has had birth parents come back to him 17, 18 years later and say, I just found out, I have cancer, or I have this in my medical history. Can you please pass that along? And he does. So the question of medical history and search is obviously a big one, and it's totally shaped now by stuff like social media. There have been international adoptees who searched and found their birth parents overseas. So the question of the original birth certificate, I think that you have to weigh as one of longevity. Was there a contractual agreement between birth parents, say 50 years ago, where they assumed that they wouldn't ever be found and didn't want to be found? Maybe for some, maybe not for all. So my suggestion generally is just to make sure you are considering all sides. But when it comes down to it, as an adoption agency representative, our primary client is the child and the best interest in the welfare of the child. And I think from a social work perspective particularly, we all want to know our history, even if we can't access lots of it. I mean, there are lots of people who have had traumatic events in their lives. They can't access, say, their biological parents because they died when they were children. adoptees are somewhat unique in that they are actively prevented from finding that, at least for a period of time. So that would be my charge to you, is that while we have to protect all parties in the adoption triad, those of us who are adults who work in child welfare are primary clients of the child. The children are not responsible for the decisions the adults make, but they do have to live with those effects. So when you're considering this, try to look at it from the child's perspective as best you can, because we're the adults and they're the children, and we need to be working for them, not the other way around.
Thank you. Are there any questions for this witness? Thank you for your testimony. Please be sure to leave the witness line. Representative Phillips, do you have any closing comments?
Madam Chair, I just want to thank you for your patience today, and for the members of your committee being not falling asleep. So we really appreciate that. No, seriously, this is a big deal to those of us. Obviously, when you look back in this room, I don't know that everybody's here on this behalf. I'm sure everybody's not. But it's a passionate group of people, and the passion comes from just the fact that there's a huge frustration and not being afforded the same rights that everybody else has. That's all we're asking. So thank you, committee, and thank you, Madam Chair.
All right, thank you. I thank your witnesses that came today and all those who came to testify on this bill. So that will conclude the hearing on House Bill 1599. And now we are ready for House Bill 1714. Representative Cooper.
Thank you.
Folks in the room, we are going to continue with our hearing process, so I would ask you to be sure that you are mindful that a hearing is in progress. Thank you. Thank you. Please continue, Representative.
Thank you for allowing me to present House Bill 1714 to you today. For the record, I am Tyler Hubrecht, representative of the 151st District. House Bill 1714 is a simple bill. It is not debating whether abortion is legal or not legal, and we're not debating whether abortion is ethical or right, or any of the normal abortion debates that we usually have. This bill does recognize that abortion is legal, and it is simply stating that any type of abortion procedure that dismembers a baby or fetus, however you want to refer to the child, is not allowed. Abortion will still be legal and available even if this bill becomes law. My goal with this bill is not to get into the normal abortion debate, but just that when an abortion is performed, it is done in as humane of a manner as possible. Kansas and Oklahoma have passed similar legislation, and this also been introduced in Michigan as well, and also filed at the federal level. This bill does have language that does provide a penalty for someone who disregards the language in this bill if it does become law. And with that, I will open to questions or beginning on the witnesses.
Any questions for the sponsor? Representative Bratton.
Briefly, good question. I'm curious how this would operate. I mean, who would be the person bringing forth charges? I mean, I just see this being really hard enforcement. I realize what you're trying to do, and I'm just trying to wrap my mind up how this would operate.
And then I've got someone here that might be able to answer that question better, if you don't mind.
Okay,
waiting,
all right.
have them
Well,
come
yeah,
up.
no, absolutely, thank you.
Okay, thank you.
Other questions for the sponsor? All right. Do you have some witnesses?
Yes, ma'am.
Yes. All right, we're ready for witnesses in favor of the bill.
Madam Chairman, members of the committee, thank you for hearing this bill today. My name is Patty Skane. I'm the Executive Director of Missouri Right to Life and also a registered lobbyist for that organization. Before the first trimester ends, an unborn child has a beating heart, brain waves, fingerprints, and every organ system is in place. There was a 2010 research project on that monitored twins for 14 to 18 weeks. And concluded that unborn twins make purposeful movement toward each other, but not accidental, including stroking each other, and it happens about 30% of each day. Abortions are illegal in Missouri after 22 weeks, but we also know that spinal cord and the thalamus, the portions of the nervous system that regulate pain, begin to form around 12 weeks and are complete at 18 weeks. In Missouri, in 2014, we had 827 D&E abortions, dilation and extraction, or evacuation abortions. There are at least 4 procedures now legal that partial birth abortion would fit under there too, but 4 that are legal that are included under that category. All of them are shown, and we have documentation for that, to be safe for the mother. They, of course, are brutal for the child. I think probably the dismemberment one more so, but they're all painful and brutal. Many times the drug is used to kill the baby in utero and then extract the baby either in pieces or intact. But those other procedures, aside from just creating abortion or starting a labor and delivering an unviable baby and then it dying, those other procedures involve the baby dying before the abortion process, either by chemicals or, say, cutting the umbilical cord and the baby bleeds to death, and then extracting the baby either in parts or intact. All brutal. The reason they don't want to, they predominantly use dismemberment is because the baby's alive. The tissue's alive. And they want that tissue for research. In our testimony, which we have a copy of the testimony of Dr. Levantino, who was an abortionist at one time, and he explains the abortion procedure that we're talking about. He is a former abortionist, and so you can see that there. I'm not going to go through all that. But in court cases, in Stenberg versus Carhart, and Justice Anthony Kennedy said, the fetus in most cases, and he's talking about a D&E abortion, dismemberment abortion, the fetus in many cases dies just as a human adult or child would. It bleeds to death as it is torn limb from limb. And in Gonzalez versus Carhart, abortion supporter Justice Ruth Bader Ginsburg pointed out that the standard D&E is in some respects as brutal, if not more, than the partial birth abortion method. Those are direct quotes. The court in Gonzalez said the state may use its regulatory power to bar certain procedures and substitute others, all in furtherance of its legitimate interest in regulating the medical profession in order to promote respect for life, including the life of the unborn. And there's an attachment in here with that information. The Supreme Court ruled, essentially, that a method of abortion can be banned if other methods are available. And I've already explained to you the other methods that are available.
we're not suggesting that some methods of abortion are morally acceptable. They are not. We are asking for accountability and action to be taken in Missouri where the dehumanizing and excruciatingly painful method of killing unborn children goes on regularly in D&E abortions. This bill carefully delineates dismemberment abortions to exclude suction abortions, the early term abortions. And Missouri Right to Life urges you to pass 1714, House Bill 1714, and strike down an unnecessary abortion method that calls into question our humanity. And I would be glad to take questions.
Thank you for your testimony. Representative Remley, you may.
Thank you, Madam Chair. On line 20, it says, sort of, I mean, part of that sentence, it says the term does not include an abortion which uses suction to dismember the body of the developing unborn child. Could you explain that?
Well, I mean, that procedure is used in earlier abortions because the baby can be, it's a suction machine with a tube and it has a cutting device on the edge of it. And basically it's sort of like like you would do a DNC, you know, and you're going in and you're in the process scraping, cutting up the baby, true. But you're also, you know, cleaning out the uterus, etc. And so that procedure is not outlawed in this bill. And we're asking for when these children are old enough to feel pain, and that's medically established, that we not put them through this kind of horrific procedure.
Thank you.
Okay, other questions for this witness? Representative Baker. You may.
First, I want to thank the bill sponsor for bringing this forward, and I just find it unbelievable that we're even having this discussion. But I'm glad that maybe we're going to make some progress here. When you said they want live tissue, could you be specific as to who is they?
Well, I think it's, you know, and you're going to hear people say that these videos that we have seen are edited or fabricated or whatever. Not the case. Yes, they have parts cut out of them because those parts are immaterial to the point that was trying to be made with these videos. But these videos prove that there is a healthy business in tissue extraction and the selling of those parts. And now, you know, who is on the selling end of that and the research industry that's on the buying end of that, we know they're there. Can I give you names as we sit here? No. But I can certainly probably give you some if I do some research.
I would like to know exactly what companies or entities are benefiting from this process.
Well, again, it's not something they're going to put out, you know, on their website. It's not something they, advertise that this is what they're doing because it's a clandestine kind of a thing, you know. It's not something they want people to know that they're doing this, and that's why they're, you know, freaking out over these videos.
You know, we had a discussion earlier this year about when an abortion is completed, there is a report sent to pathology, but we found out during our hearings that there's really no accounting for the entire baby, just a sampling. And maybe what we could do to augment this would be to require that the entire baby is sent for pathology so we have some assurance that these techniques have ended.
Absolutely. And of course, when that bill was passed many years ago, no one ever even considered the possibility that we would be harvesting tissue and organs from these children. You know, the pathology report was basically to determine, you know, sex and you know, different things like that for what we now have in our reporting requirements, even though our reporting requirements are not as detailed as we certainly would like them to be. But that's what that pathology report, I mean, the actual law does not require them to send all the tissue. And so it's just a sample. And so what they do with that tissue, as we have heard in a number of these investigative hearings, nobody seems to know.
At one time, many years ago, of course, they disposed of it, either down the garbage disposal or the garbage. I mean, you saw all kinds of news reports of that. But now we don't know.
So other states that have passed similar laws, have they withstood any court challenges as?
They're currently in the courts now. So, yeah, I mean, there's fairly recent passages of these laws in Kansas and Oklahoma, and they have been enjoined, and so those are going to the court process now. But there are certainly, as I quoted in here, and it's in here in this testimony that we turned in, quotes from the Supreme Court indicating that we're certainly within their guidelines to restrict how these abortions are done.
Okay, thank you. I appreciate your information. Thank you, Madam Chair.
Representative Beard.
Thank you. My question is, if this allows D&E, that's I think what I'm understanding from you, but what procedure would then be used for abortion purposes after this bill?
Well, as I said, if you look at our statistics from the Department of Health, it determines what procedures were used. Unfortunately, they're pretty broad. And a D&E abortion is listed there, and as I said, there were 827 of them in 2014. That's the latest statistics we have available. But within that D&E category, there are a number of different procedures that could have been used. Our reporting requirements don't detail it enough for us to know what they are. But we do know that the predominant way to do these abortions is by dismemberment.
Okay, so I don't really know, if you don't dismember and extract, then what's the other option?
Well, as I said, they involve either, if it's an unviable baby, fairly,
right, young.
Okay. Yes, fairly young, they might just, I'm losing the term, but start labor and deliver an unviable baby and the baby dies. That's one way, not probably the predominant way. They also kill the baby in utero, either with a chemical they inject into, I think it's called digoxin. They inject it into the baby's heart, and the baby basically has a heart attack. Not an, unpainful process. And then the baby, after dead, is either cut into pieces and extracted or extracted whole.
Okay.
And also there was one abortionist who actually reported that she cut the umbilical cord and then waited, and the baby bled to death and died in utero. And again, you have the choice of cutting that baby up or extracting it whole. I mean, the point though is they don't want to use chemicals because chemicals get into the cells of the baby, and they don't want cells. They don't want chemicals in those cells. They want pure, sterile, live as possible tissue.
Okay. Thank you.
Other questions? Thank you for your testimony. Others in favor?
And Fair Committee, for the record, Carrie Messer, on behalf of Missouri Family Network, we'd like to go on record supporting House Bill 1714. Don't want to take up too much of your time. I was a little confused over some of the same questions that Representative Beard was asking. My understanding of the bill is referring to the dismemberment of the live baby. So if the baby has expired from whatever previous during the process was done, then that dismemberment would not fall under this definition. So I hope that might clarify the point a little bit. But I do know this. A number of years ago, both the state and the federal government passed laws to prohibit the sale of fetal body remains from abortions. And that's been kind of at the crux of the videos that came out this last year, and some of the debate, and then there was some discussions and debate here in Missouri. We're all a little frustrated that subpoenas in the Senate were ignored, and people would not come to the table to answer a lot of questions. And so there's the rhetoric out there, well, this isn't happening in Missouri. We don't really know one way or another whether fetal parts are being sold or marketed out of the state of Missouri or not. What we do know is this whole process was created and developed many years ago with that intent in mind. And that's what the previous witness, I believe, is trying to say, is that there was the intent. And so the baby is alive when those limbs are pulled from its body. And that is about as brutal as you can get. And that's what this bill is addressing. Thank you very much.
Any questions for this witness? Are there others here to speak in favor of the bill? All right. Pause for just a minute. I have a question. Okay. All right, is this modeled after other states' legislation?
Yes, ma'am.
Same thing, okay. Appreciate that. All right, is there, I think we're ready to
We
move
kept
on.
it short on our side.
Well, let me see here, because I'm timing it.
Yes, you told us 20 minutes. We were working
You know
very hard
what,
to keep it.
you're within that, so you're
Very
good. You're good, thank you.
Very good, thank you.
All right, those in opposition, please.
Good afternoon, Madam Chair, members of the committee. For the record, Sarah Rossi, Director of Advocacy and Policy with the ACLU of Missouri. My testimony will be brief today. I'm glad that we don't have to debate whether or not abortion is legal in the state of Missouri. I'm glad that we can see that it is legal in the state of Missouri and it's a constitutionally protected right. So that'll save me some time. I don't have to talk about Roe v. Wade, which is great. The rest of my argument will be brief. I think this is actually the most cut and dry line when it comes to the slew of abortion regulations that are being proposed this session. I appreciate proponents bringing up the Kansas bill that was passed and the Oklahoma bill that was passed. Both of those laws were enjoined by courts in both of those states because they are patently unconstitutional. They're patently unconstitutional because the Supreme Court has said multiple times that banning this particular procedure is patently unconstitutional. The differentiation that we're talking about here, and I think some of the information has gotten a little jumbled and perhaps been presented a little bit disingenuously, but there are two different procedures that we're talking about here. There's intact D&E bans, and there are D&E bans. So the intact D&E ban has been banned in the state of Missouri since 1999. That's no longer an issue here. What this bill purports to do is ban a procedure that is the most common procedure used for abortion, pre-viability. And the Supreme Court has said twice in Gonzalez v. Carhart and in Stenberg v. Carhart that the ban on intact D&E abortions, which is what was banned in Missouri in 1999, that withstands constitutional scrutiny. But they said but the first case was a ban on both D&E ban and intact D&E ban, or D&E procedures and intact D&E procedures. That law was struck down because it banned both of those procedures. The second case I mentioned was just a regular D&E procedure ban, and that was also struck down by the United States Supreme Court because the court was very clear that a ban on that type of procedure, which would basically almost completely ban pre-viability abortions, is far and away past the undue burden standard that was iterated by the court in Planned Parenthood v. Casey. So you have Planned Parenthood v. Casey in 1992. That's where the undue burden standard was first used, and I've explained that to this committee, I think, a few times at this point, this session. That undue burden standard was used to analyze a ban on this particular procedure, the exact procedure that's being referenced in this bill, and both times the court found that you can't ban this procedure under the undue burden standard. You can't. It's very cut and dry. I don't know how else to explain it. So the Kansas bill has been enjoined for that reason, and the Oklahoma bill has been enjoined for that reason. Passing this bill puts the state of Missouri in a very precarious position when it comes to their legal legs to stand on. And again, Missouri is a state with so many restrictions on abortion already. There's a point where you go too far and you're gonna have to reckon with the courts. And this bill is exactly what that is. I can't think of another bill that's come up this session that is so clearly unconstitutional as this bill. We're vehemently opposed. I think it would be in the legislature's best interest and the best interest of the state of Missouri to not pass this bill because the challenges that have come up with similar legislation in other states like Kansas and Oklahoma have succeeded in the courts and they've been enjoined. And it's a waste of the resources of the legislature and a waste of the resources of the state of Missouri. And I don't have a written testimony, but I do have my own personal copy of the Kansas decision with my own highlights in it that I will leave for the committee.
Do you have the dates on those enjoyments?
They were both in the last 4 months. I think Kansas's was, oh man, I want to say Oklahoma's was October. They were both at the end of last year. It's the Kansas Court of Appeals, and then
Kansas Court of Appeals.
Yes, and that's this decision I have here in my hand, and I'm happy to email the Oklahoma decision to the committee as well. I want to be clear though that those bills were enjoined because of the content of the bill. It wasn't because of standing, it wasn't because of procedure, it wasn't because of any technicality. It was enjoined because of the content of the bill that banned D&E procedures. And they were simply following Supreme Court direction.
And when did you give us the date, the Supreme Court?
The two cases that I referenced from the Supreme Court were in 2000 and 2007. Casey was 1992, Stenberg was 2000, and Gonzalez was 2007.
Other questions for this one?
Thank you
very much for your testimony.
I'll just leave this here, unless you want me to hand it.
That's fine. Okay. Yes, that's fine. Others to speak in opposition to the bill?
I have copies. Should I leave those here too?
That'd be fine. Thank you.
Hello, my name is Maddie Mead, and I'm with Planned Parenthood Advocates in Missouri, and we represent the Planned Parenthood affiliates in Missouri who provide preventive health care to and sexual education to over 60,000 Missourians across the state. So services include largely preventive care, access to contraception, sexually transmitted infection screening and treatment, cancer screening and treatment. And we also provide safe and legal abortion. We are proud of our high level of care, and we provide that care to anyone who walks in our doors. We care no matter what. And I am here to speak in opposition to the bill, and I'm going to attempt to try and introduce some medical expert opinion. We have a physician who really wanted to be here to testify against the bill. Was not able to attend, so I have just a few pieces from his testimony, which is also written here, and I'll submit. So imagine you're sitting with your trusted cardiologist, and you're discussing your very serious heart condition. And after a thorough consultation, you decide with your physician that angioplasty is the right approach for your care and your health. And in barges a politician and says, oh, no, 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 let's go with open heart surgery. That would be politicians practicing medicine without a license. And that is exactly what's at issue in this bill here today. And so I would like to bring in a medical voice. This is Dr. Gray, who's an OBGYN in mid-Missouri. He's been practicing for over 30 years. He says, I am writing to express my strong opposition to House Bill 1714. As an expert in obstetrics and gynecology and a specialist in women's health care, I am alarmed at the unprecedented attempt of Missouri legislators to dictate how physicians should perform a safe, common, and evidence-based surgical procedure. This bill represents unwarranted intrusion in the doctor-patient relationship. The bill would restrict the safest and most expeditious way to terminate a second trimester of pregnancy. In closing, he says, it is my strong belief that the laws in Missouri should not be changed in this way. We physicians serve our patients who are often struggling with difficult decisions the best when we represent their autonomy. So they're serving their physicians or their patients the best when they respect their autonomy, their dignity, and the right to the safest care possible. Physicians must be able to make these kinds of decisions according to the best medical evidence and their best medical and professional judgment without political interference. I therefore urge you to reject this harmful measure. And not only is it this one single physician, but there are major medical authorities, including the American College of Obstetricians, Gynecologists, and the World Health Organization, who oppose these types of bans because they believe that the doctor-patient relationship should be prioritized and preserved free from political interference. These bills are, let's be clear, part of a broader strategy that's really about banning all abortion in Missouri, and it's, as we mentioned, a bill that's taken from other states. This is a national strategy, and it needs to be recognized as part of that. And of course, as Sarah Rossi just mentioned, that the courts are starting to object. And just to clarify, the Kansas decision is actually, there were two decisions where the bill has been enjoined, both at the lower court and the appellate level, and that appellate ruling was just 2 weeks ago, and Oklahoma's was earlier. So just to clarify it on that there are significant constitutionality questions with this bill that I think the ACLU spoke to. And I would just close by saying this is the wrong priority for our state. There are things we can be doing that would actually promote the health and well-being without harming women's health and involving politicians into medical decisions. Things like expanding Medicaid. Boom, we have access to healthcare for thousands of working Missourians. As I spoke before this committee, we also urge you to support comprehensive sex education. There are policies that would advance the health of Missourians that we would like us all to be able to agree on. And then finally, the underpinning accusations supposedly motivating these bills are false, have been proven false at the congressional level. In fact, the folks behind the false claims and those movies have been indicted. They're the ones who have been found in violation of the law, whereas state after state, investigation after investigation, including in Missouri, which you all have access to, those investigations have demonstrated that those allegations and the things that people keep bringing before your committee are not happening, not in Missouri and not across the country. So I just wanted to clarify that once again. I'd be glad to take questions.
Well, thank you. Now, give us your title again, Ms. Neely.
I'm the Director of Policy and Organizing for Planned Parenthood Advocates in Missouri.
Yes. Where's your office?
I'm based in St. Louis.
What's your address?
4251 Forest Park Avenue.
Okay, thank you. You know, we did have those hearings this fall, and we had a very difficult time having anyone from Planned Parenthood come and visit with us so that we could make some sense out of what we're hearing on the videos, which I want to go on to say, I'm so glad you brought that up. The executive summary from Coal Fire, which uses industry standard tools and technology to look at the video, said their analysis was that the recorded media files contained indicates that the video recordings were authentic, and they show no evidence of manipulation or editing. The conclusion is supported by the consistency of the video, file date, and the time stamps, the video time code, as well as the folder and the file naming the stream or the scheme, I guess, of it. Uniformity between the footage and the cameras of the two investigators also support the evidence that the video recordings are authentic. With regard to the full footage, which you see on YouTube, the videos released by the organization, edits were made to these videos, and those videos are the kind of editing that took place is the kind of editing for allowing for commuting from one place to the next, waiting, adjusting recording equipment, meals, restrooms, breaks, lacking pertinent conversation. Any discrepancies in the chronological record of the time codes are consistent with the intentional removal of this non-pertinent footage within the report. CoFire is an independent organization that looked at the videos and found that the material recorded there had not been manipulated. So those videos are, in fact, what they are. The fact that the Texas grand jury has issued an indictment, I believe that indictment is on falsifying a driver's license, and the other one is unconceivably that the makers were actually really trying to buy the body parts. Now that is at a very low level in the court right now, and I'm sure it will move its way on up the chain. So with no certainty, can you say that those videos are inaccurate, falsified, or something that we in the state of Missouri should not be concerned about? Within those videos, St. Louis was mentioned as a place where baby body parts could be found. And I guess I would further say that we'd be happy to re-engage that committee if Planned Parenthood would be willing to come before it.
So there's so many things to address in those set of things. I'm not familiar with this group that you're referring to. I am familiar with a certified videology technician company that has issued a report showing, for example, that there were over 40 cuts in one piece and found them to be inadmissible as evidence. And I believe Congress has reiterated that in terms of their committee, which at the highest political level of this country, investigation of your colleagues in Congress, led by the Republican leadership of those committees, have found that there's no evidence that Planned Parenthood violated law and that in fact we comply with law. So that's congressional findings there.
Oh, wait, they had not violated law? Is that what you said?
Yeah.
Okay, so you're not saying that the videos
No, they found that the videos were inadmissible because of the manipulation that a certified videology technician found in all of them. And then I also just have to correct the statement that the full length have been available or that you can find on video. They have not. The full unedited versions have never been released, so that's not available.
It was released to the CoFire, and that they are the ones who investigated that.
Like I said, I'm not familiar with that report.
Well, I am.
So
I have that information from Washington, D.C.
I will just restate that the investigations and the thorough investigations that have been conducted have found that Planned Parenthood complies with all the laws. And you have access to examining those investigations, and you had testimony from the interim director of health earlier this year that not only did the Attorney General conduct investigation, the Department of Health and Senior Services conducted one as well and found that we're compliant with those. What I came here today to talk to you about in a hearing about a piece of legislation was this legislation, and I'm glad to share Planned Parenthood's views on this type of legislation, as well as all the medical information that we would hope would drive the decisions made by the legislatures, as well as to offer what we think to be common sense priorities that the legislature could spend time on that would improve people's health, as opposed to harming women's health and interfering in the doctor-patient relationship and substituting political will from a subset of politicians for the decisions that physicians make after years and years and years of medical experience.
Well, I can assure you that everyone on this committee is very concerned about the health care of every woman in the state of Missouri, along with her unborn children. And the purpose of our investigation this summer was not the purpose of furthering a kind of political agenda. It was for the purpose of getting to the bottom of this question. We found that we could not get to the bottom of this question, and we found, many problems, as you said, with the Attorney General's report, which you sound like you really rely heavily on, was for 1 month in the state of Missouri. What we saw from that, there wasn't anything conclusive about that. It simply said that from Planned Parenthood over to the pathologist's office, these are the procedures that had taken place. We had testimony from the pathologist himself, which said that there were a number of months that they did not turn reports into the department at all. We had testimony from the interim director in our very first hearing that said they are yet still trying to pair together the documents that show an abortion has taken place and the pathology report. There's nothing cut and clear or transparent about this. And Planned Parenthood has not come to help us and aid us in any way to achieve any sort of transparency in that issue.
We have provided all the documentation for those investigating through the Attorney General's office and the Department of Health and Senior Services, and through those agencies to which you have spoken, you have access to all of that. We've given it all over. And I believe that in the testimony from the interim director, he indicated that they were, and this was 2 weeks ago, 80% through looking at all those reports and found no inconsistencies. And he also indicated that their understanding, observation, and oversight of how tissue is managed after an abortion found that there could not be the full sample was going to pathology, and the way that the tissue needs to be prepared is such that the tissue cannot be used for anything but pathology. I heard him say that. So I just think that
that's right, and we're not, that's the part we don't really need to investigate very fully. The part that needs to be investigated, that we needed the Planned Parenthood providers to come and talk to us about, is from the point of abortion before it enters the sample preservation to go on to the pathologist. I mean, I hope that you can appreciate that position.
I don't know what other information you could be seeking that hasn't already been released, and that is the point. You have it all. You have it.
We have all of nothing, basically. We have all of things that we cannot trace from one place to the next so that we have transparency. So when you talk about the bills that are coming forward, we are just trying to create that transparency by law, which could be provided to us via testimony from Planned Parenthood.
What I would say about this bill that we're discussing today has nothing to do with transparency. It has to do with inserting political decision-making for medical decision-making, and it's not only unconstitutional, it's not good for the health of Missourians, and it's not considered in other medical procedures. And so my plea with the committee is to focus on things that we know, they're demonstrated, evidence-based, proven to improve the health and lives of Missourians. Medicaid expansion is right there before you that could immediately impact people's lives.
Well, so noted. And comprehensive women's health care would do so much more for women in our state than carving out dollars and sending them to the Planned Parenthood clinics, where the availability of care is very limited. I mean, there's no treatment there for high blood pressure or diabetes or any of the other common or chronic or complex diseases that women may have. Yet, if they had the opportunity to make that the first stop for their health care, then they could become, they could receive more comprehensive care and be healthier women in the state of Missouri.
We believe that the over 60,000 people who seek out our services and get very high standards, very quick access to a very specialized, yes, set of services, and that the people who are in need of publicly funded services, who seek them from an expert like Planned Parenthood, deserve to seek them from an expert like Planned Parenthood and get in quickly and get access to those services. There's no dispute that there are other providers who also serve those who are in need of publicly funded services, who provide a broader suite of services. There's no dispute, and we're glad to partner and work and refer with them, but the patients who choose Planned Parenthood do so for a reason. We have highly qualified, highly trained, expert medical providers, and we provide that care, and our patients keep coming back to receive that care. And I don't think that they would appreciate you telling them that they don't know what kind of care they should be seeking simply because they're in need of public funds.
The public funds go into FQHCs, thank you, they go into community health centers. Public funds go into healthcare facilities all across the state. And those kinds of facilities are vast across the state of Missouri, and those people are just as qualified as the specialized care that they received at a Planned Parenthood center.
I'm sorry, I in no way meant to imply that our colleagues and coworkers in the public health network are not qualified. What I was saying is that by specializing in women's reproductive health care and doing evidence-based contraceptive care and screening and treatment is something that patients want. They keep coming back for it, and there's a reason. We specialize in it.
So you're more advanced.
Some patients prefer to
providing that care
come.
than all the other medical providers in the state of Missouri.
I think our patients make that decision of where they want to go for their services when it comes to this set of services. I think our patients are the ones who speak for where they want to get those services. And yeah, we do hold ourselves to a very, very high standard and focus on that kind of care because honestly, women's reproductive health care, preventative care, or evidence-based contraceptive counseling is not necessarily what you find in every place of care. Not every level of physician or nurse practitioner specializes in every level of care. There are levels of care that we don't specialize in. We might provide basic screening, but we don't specialize in them. So we understand that other providers would have more expertise that would draw patients to them, and that's the point I'm apparently failing
Give
to
me
make
some idea
about
of specialized care that you provide. What level of specialized care do you provide there?
You go to a physician or a provider who is not familiar with the full suite, and there is a very, very full suite of rapidly evolving forms of contraceptive that have a different impact depending on each individual woman's circumstances and experience with previous kinds of contraception. And some physicians aren't familiar. They just don't have time to keep up with all the evidence on the rapidly evolving set of contraceptives that are available to people. And that's what we spend our time doing and that our standards require. So that is an area where you might go to one physician who's only familiar with oral contraceptive pills and when in fact the evidence-based contraceptive counseling might mean that that woman is actually a better candidate for an IUD. And that disparity does happen when you have a physician who doesn't have the time or a provider who doesn't have the time to specialize and focus on all the evolving research around the contraceptive care. It happens, and that's why people choose to come to Planned Parenthood many cases because they know they can get that kind of evidence-based counseling in that specific area focused on contraception.
So physicians, other physicians, other healthcare providers in Missouri do not have to take CME courses. So they can't be, they just wouldn't know about these things. I mean, I still don't understand how you have an exclusive pipeline on women's health care, and that the health care that you provide to women is far better than health care that is provided throughout the state by other providers. And they have, as I said before, the ability to provide diagnostics for a whole range of many of the common diseases that individuals have and conditions, and are able to write prescriptions for those, to put them into a course of treatment. They're able to refer them on to specialists if that need to be happening. they have mental health available, true mental health that is available for them to take place. And I guess to hold yourself out as being able to provide that care better than any other facility in the state of Missouri is, you know, I find that really unbelievable.
Two things. I would like to offer or suggest of getting a medical expert, someone who is a degreed specialist, to address this with you at any time. We can definitely follow up because I clearly am failing to characterize the way specialty in medicine operates. And I'm just not getting it across.
You're talking to the wrong person like that. Both my son and my husband are physicians. I know exactly how medicine operates.
And so again, what I'm saying is that I think there's probably somebody better and more versed in fact using terms that you're more familiar with who can get that across. And again, I'll just say that what our patients are seeking and we're providing and they're returning is what we should focus on from my perspective here, and that telling those patients that they can no longer access public funds because they prefer to seek out the care from Planned Parenthood is discriminatory to people who are in need of publicly funded services. And I think we all agree that if those funds are allocated, we want them going to the place where the people in Missouri want to receive the care. And that is what is occurring now in terms of Planned Parenthood patients in need of publicly funded seeking their care from us.
Yes, we here in the state of Missouri agree that women's health care is so very important. That's why it's provided in places like in my town, we have a medical missions for Christ. And the RV van from the University of Missouri, which is MD Anderson, comes to the door and does the mammogram screenings there. And there are facilities like that all across the state of Missouri. We want to be sure that rather than one specific agency being able to utilize all those family planning dollars that are available through our federal programs, we want to spread that out throughout the state of Missouri. There are so many more facilities that make those things available. And again, the providers there are I mean, I guess they could go to your website and look at all the different contraceptives that you provide if they feel like they need to match knowledge for knowledge. I mean, I'm not sure what you're saying there, because I believe that they are certified. They take CMEs every year. They receive medical magazines and journals. They have access to the internet and to their colleagues. They come together with their colleagues at different events and conventions. So I just don't see that there's a discrepancy in the service that's provided in the state of Missouri. We have so many more facilities that provide comprehensive health care. So I don't think that there's any degree of trying to deprive anyone from health care. We want it to be better, comprehensive health care for women.
We are proud of the high level of comprehensive specialized care that we provide our patients and their interest in seeking us out and ability to get quickly scheduled appointments. I don't know what else to speak for. I'll just let the patients speak for that.
Okay, thank you. I think that Representative Bratton has.
To briefly inquire. Now, with this bill, would abortions still be able to be performed if this were to pass and become law?
This is not a complete ban on abortion, no.
Right. So, I mean, the ability to perform that abortion would still be there. The healthcare would still, that you're calling healthcare, would still be at people's disposal if they so choose.
The safest form of abortion in the second trimester would be banned by this bill.
Okay. So you brought up a comparison of, say, a cardiologist, and if the state stepped in. If the state stepped in and made it to where a doctor was not able to carry out a heart surgery, what would be the end result of that patient? What would happen to that patient if his heart surgery was unable to be performed?
The example I was using,
Well, say it was a bypass, I mean, life and death, but we banned it. What would happen to that patient?
what the example I used was that
Well, I'm asking my example.
maybe I could finish what I'm saying and
Well,
then I
you're
could
answering my question. If there was a bypass that the patient had to have, and we had banned that and could not receive that care, what would happen?
I assume the doctor would try and find the best way to treat
What would
their
happen to
patient.
the patient if he was unable to receive the care?
We are at the extent of my medical knowledge of what would happen in that specific.
I think you know what would happen, that the patient would die. Now, if abortion was unable to be performed, what would happen?
If the safest form of the abortion that
With
the
medical
physician.
fact, I'd like a medical opinion, or at least some level of medical accuracy to your answer.
Well, so from the physician testimony,
Well, we're talking about comparisons she made, Representative, so.
So from Dr. Gray's testimony, he says that
I'm asking of the question, making comparison of what you compared, what would occur if the abortion was not carried out?
so I think any number of things could happen. That the woman could seek care in a place where a state where the procedure
If the
was
abortion
advanced.
was unable to be carried out, what would be the end result? Okay, thank you. I appreciate it.
I'm so sorry I wasn't able to answer your question.
I was just thinking a little bit about what you were saying and seeking health care. And I'm thinking about a question. Sorry. Just trying to comment. Okay, I have health insurance. I have very good health care. I can afford it. And when I go to the doctor, I go to my internist for general purposes. I go to my OBGYN if it's something dealing with that specific area. You know, I go to different doctors depending on what my issue is. And I'm thinking that maybe Planned Parenthood doesn't provide everything that, I never get the letters right, FQ, so that's QHD. Okay. They don't provide everything that they do, but maybe Planned Parenthood, on the other hand, just like my OBGYN, is a little more versed and right up to date because we're only doing a very narrow practice. They may be more up to date than my internist. You know, I mean, I have learned a lot about different kinds of birth control working with foster children of all things, but, you know, because of kids. And I'm just thinking maybe that's the kind of services that they provide that the FQHC doesn't. I mean, that's a possibility. And sometimes people need special care and they don't know where to go. I mean, I ran into a young woman and she was telling me about how Planned Parenthood saved her life. And I said, really? How'd that happen? And she said that she wanted to get birth control and she was in college. And she heard Planned Parenthood, but she didn't know of any other place to go. And she went there and discovered that she had very early stages of cancer. By doing a screening before they even had birth control. And she said she didn't know where else to go. She wasn't at home or she had family. She was in school. And so she says because they were there, she heard because everybody's heard Planned Parenthood, whether they were not, it was a place where she could go and get the kind of help that, you know, she's going to get birth control, but maybe she had this other thing going on. So maybe that is the same kind of thing that you guys were talking about.
I think that the level of healthcare is provided, is consistently provided.
Well, then,
I
why
mean,
would
when she
you
got,
guys
she had QHC, they found out that she had.
Yeah, but she doesn't, do they all have the same name?
That's just for federally qualified, healthcare center. Federal dollars flowing to the states. So how many of them are there? 500.
I have no
500
idea what it
there is, cities.
Like, I mean, I don't know where I've heard the one, and like the one young woman.
Just touching the name. And they have a, scales.
Yeah. I'm just thinking about what's known, what's known broadly. I don't know, but I'm thinking specialized narrow care is a lot different than
Other questions for this witness? Seeing none, thank you. Please
Thank
leave
you.
a witness form.
Okay, Speaker.
Thank you. Others in opposition?
My name is Allison Dreeth. Good afternoon, representatives. I'm the executive director of NARAL Pro-Choice Missouri, which was founded in 1969 and is the state's largest grassroots organization working to protect reproductive health care in the state. NARAL stands in opposition to House Bill 1714. This bill is not only trying to ban the most commonly used method of ending a pregnancy in the second trimester, but it also represents an unprecedented attack on women's health, personal autonomy, and the doctor-patient relationship, potentially forcing physicians to subject women seeking safe and legal abortion services in the second trimester to additional invasive unnecessary procedure, or to lose access to abortion services entirely, which, as we all know, is constitutionally protected. In addition, as my colleagues before me have stated, not a single court, state or federal, including Kansas and Oklahoma, has upheld these bans. Because I know you are all lobbied by Missouri Right to Life and other anti-abortion groups, and that you are politically aware folks, I'm also certain that you know that just this past year, these types of bans were overturned in our neighboring states. I must also add that anytime the Supreme Court has had a chance to uphold a pre-viability ban, they've said no thanks. So that means this will be a very expensive loss in terms of court fees for the state of Missouri and for you small government folks, which should be very disappointing to Missouri taxpayers. Major medical groups oppose potential political interference and medically unnecessary procedures similar to what is found in this bill. The American Congress of Obstetricians and Gynecologists stated that D&E bans, quote, raise serious safety and health concerns for women as well as intrudes unnecessarily into the patient-physician relationship, end quote. Missouri women have already faced a myriad of obstacles when attempting to access basic reproductive health care services, including a 72-hour mandatory delay for women seeking safe and legal abortion and restrictions on insurance coverage for abortion services. Rather than focusing on increasing the number of policies that are known to support women and children, like Medicaid expansion and paid family leave, politicians in Missouri have spent their time enacting abortion restrictions that do nothing to improve women's health and safety, unlike what the chairman thinks that we do in the state. That's my testimony. I also have two that were left here with me today from the bill before us that are also in opposition. So I'll leave those as well.
All right, thank you. Are there questions for this witness? Thank you. Others in opposition? Anyone for informational purposes only? Do you have any closing remarks?
I just want to thank the committee for their time and just to remind that this will allow abortion to take place. We're just wanting to make sure that it's done as humanely as possible. Thank you.
That concludes our hearing on House Bill 1714.